Hello everyone, I'm Rajni Yadav. I'm your tutor for today's class. I'll be taking CPC for SEBI Grade A examination. And in today's class, we'll be covering section 9, 10, 11, 12, 13 and 14. And we'll be covering this subject from the perspective of this exam as to what is required for this exam's preparation. We'll not be going in very depth of this section as we'll be focusing only on those things so that we are able to solve the multiple choice questions, which might come and which might be asked. So let's start with today's session by part 1 of CPC, which starts by section 9. Okay, section 9 says courts to try all suits unless barred. It says the court shall, subject to provisions herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which the cognizance is either expressly or impliedly barred. Right? So, what they're saying is, courts have the jurisdiction to try all suits of a civil nature. When you read the section, they are saying all suits of a civil nature. So what you can think and say is that by this section, it is giving the widest possible jurisdiction to the civil courts. And at the same time, it is giving the broadest right to an individual to file a civil suit. Okay. Now it is saying suit of a civil nature. A very common question, very basic, which anyone will ask. What is a suit of civil nature then? What is the difference between a civil suit and a suit of civil nature? Right. So whenever there's an existence of substantive legal right and there's a violation of that civil legal right, then that is called suit of a civil nature. However, in some suits, apart from civil legal rights, there may be some socio-legal issues also involved, and the determination of a civil legal right depends upon the determination of that socio-legal right. Then that will be called as a suit of civil nature. So what you can understand is that when we talk about a civil suit, it is basically talking about all the civil rights and all the civil disputes which are there. Okay, but when we talk about suit of a civil nature, then we're talking and covering along with those civil rights and disputes, along with them, some socio-legal aspects are also involved. Then it is called as a suit of civil nature. So a civil suit is narrower term, and a suit of civil nature is a broader term because it is including, because under a suit of civil nature, both a civil suit along with some social religious issues are also involved, right? Now, in the definition, we find words, the cognizance of which is either expressly and impliedly barred. So what is expressly and impliedly barred? Expressly barred means whenever there is a special court which is created by any legislation and it creates an exclusive jurisdiction clause, like in the cases of rent control acts, labor acts, and insolvency acts, family courts, etc. These have exclusive jurisdiction clause. That is, if any dispute arises pertaining to these matters, then the suit will be filed in these cases only. So herein express bar is there. In these cases, you can't go in a normal civil court to file a suit, right? You will have to go to these special courts only. So this is the express bar. Now, when talking about implied bar, in some cases, there are special courts which are created and they do not have any exclusive jurisdiction clause, or they're silent about exclusive jurisdiction clause. So it might happen that the person or the plaintiff might think that he can file the suit either in any normal civil court or in that special court, but this is not the case. in such cases, like Consumer Protection Act, there's nothing clearly written about exclusive jurisdiction clause, right? So in such cases, we go into the intention of the legislature, and when you read the legislation, you will get to know and you'll get an idea that the intention of the legislature was not to let the plaintiff to file the case in any normal civil code, but to file it in any to file it in the special code which are created for this purpose, right? So this is an implied bar which they're talking under this section. Now this section has got two explanation, and we'll start reading explanation. We'll start by reading explanation 1. A suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So when you read explanation 2, you'll get to know that they are not defining civil suit of a civil nature in this explanation. Rather, it is saying that if in a suit right to property or to an office is involved, then irrespective of the fact that it involves any religious rites and ceremonies, it will still be a suit of civil nature. That is, what they're saying is that if in any matter or in a dispute, there is a dispute related to right to office or right to property, but along with this civil dispute, there are some social religious issues also involved, some social legal religious issues are involved, then also it will be a suit of civil nature. Now let's come to explanation 2. It reads, for the purposes of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1, or whether or not such office is attached to a particular place. So explanation 2 is an explanation to explanation 1. It is very much clear. It is explaining, further elaborating on explanation 1. And it is saying it is immaterial if there is any salaries involved to such office or not, which they are mentioning in explanation 1. It will still be a suit of civil nature. Now let's take some examples, and because sometimes they may ask questions like if this right or if this issue is a suit, or if this case is a suit of a civil nature or not. So I am covering few important ones, like right to take out religious procession or worship. Since religious procession falls under Article 25 of Constitution, that is, it is a legal right under our Indian Constitution under Article 25. So what we find in this is there is legal right also involved and social religious issue also involved. So this is a suit of civil nature. And similarly, on the same ground, in the case of the right of a Parda Nashin lady to observe Parda, right? It is under Muslim personal law. The ladies have been given the right to observe Parda. So it is a right given to them under Article 21. So in this, some religious issues are involved along with legal rights. Legal rights are attached to it. Article 21 of the Constitution is attached. Therefore, it is a suit of civil nature, right? Now, let's talk about next, person expelled from a caste. Whenever a person is expelled from a caste, there's nothing legal issue involved in that. It is purely and totally a social issue. Therefore, it is not a suit of civil nature. Right? Now, right to hold religious office. It is like being Mahant or something like that. Then it is also not a suit of civil nature. Right to hold hereditary office. It is a matter of legal right. If you know Bhuri Nath's case, in which was related to Vaishno Devi Shrine. In that matter, it was said that it's a legal right to hold hereditary office. Therefore, it is a suit of civil nature. So now I hope you guys are clear with section 9, and by reading it, we all can come to the conclusion that section 9 is the gateway to CPC, because it is giving entry to all the issues which have some legal rights attached to it, along with the breach of some civil right. Then it can all fall under this suit of a civil nature and can be filed as a civil suit, right? So now let's go ahead, and now we'll be reading section 11, which talks about res judicata. It says, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between the parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. Right? So now this section has 8 explanations that will be dealing after covering the main provision of this section. Right? So yeah, first of all, this section 11, which talks about res judicata, is based on 3 maxims, that is, nemo debet, bis vexari pro onum, aidum causa. That is, which means a person should not be troubled twice for the same cause of action. Right? Interest republicae ut set finis litiam, which means there should be an end to limitation. Third maxim is res judicata pro veritate occupitur. A judicial decision must be accepted as correct. Right? See, when we talk about the principle of res judicata, and when we read the main section, we come to a conclusion that under this section, there are many conditions. When they are fulfilled, then the principle of res judicata applies to it. So the conditions which are there are that there should be, first of all, there should be 2 suits. That is, 1 subsequent suit and 1 former suit. And explanation 1 is actually talking about this. So we will cover explanation 1 with this part. The expression former suit shall denote a suit which has been decided prior to the suit in question, whether or not it was instituted prior thereto. So what is a subsequent suit? What is a former suit? A subsequent suit and a former suit. See, a former suit is that suit which is decided earlier, which is decided first. It is not based on the concept that which was filed first, or, it's not at all on that basis. It is on the basis which suit is decided first. It may happen it was filed later, but if it was decided earlier, then it will be a former suit, and the suit which will be decided later, and the other suit will be basically a subsequent suit. Okay, please give me a minute. I want. Now, the other condition which is there in this section is matter in issue in subsequent suit should be directly and subsequently in issue in former suit, right? That is what they're saying is the matter which we are raising it in the subsequent suit should be and has been directly and substantially in issue in the former suit. And the parties between the 2 suits, subsequent and the former suit, should be same, or under whom they or any of them claim should be same. So when they say under whom they or any of them claim, By this they mean, like, suppose there's a suit between A and B, and in between A dies. So what will happen? The son, daughter, LRs of A will fight and continue the suit, right? So this is where they're saying under whom they or any of them claim. And the title of the suit in both the suits should be same. Suppose the subsequent suit is a partition suit, and the uh, the former suit was related to some matrimonial matter between the same party, then they're not talking about this thing in this section, right? Competency of the court. They're talking, so when they're talking about the competency of a court is, they're talking about the competency of the former court. So like what they'll check is the matter which is now filed in the subsequent court, we'll check the competency of that matter in the former court, right? If is that former court competent to try that suit, that we will check and test, right? And the last word is heard and finally decided. What is heard and finally decided? By heard and finally decided, it means that the judges have applied their mind, and evidences were recorded, and then they came to a conclusion and the judgment was passed, right? That the case was decided on merits of the case. So this is what is called heard and finally decided. So if these conditions are fulfilled, then what is the result? The result will be that it will be hit by the provision of res judicata, and now the trial and subsequent suit will be barred, right? So this is what they are trying to say. So the gist of this section is that if all these conditions, like there are two suits and the matter directly and substantially in issue in the subsequent suit was also there in the former suit, the parties are same, the title is same, competency of the court, and if it was heard and finally decided, then the trial will be barred. So what we see is that this provision is there to prevent the multiplicity of suit. Because what will happen? Suppose a case is decided, again, you did not like the judgment, you'll file the case again. Suppose there was a case between A and B, and the case was dismissed. So what will happen? A will again file the case. And now again, suppose judgment did not come in the favor of B. Now B will file the case, and it will keep on going on and on and on. So that is why, just to prevent these things, the multiplicity of suits, this provision is put in the CPC, right? Now let's read all the explanations one by one. We have already covered explanation 1. Now let's talk and discuss explanation 2. For the purposes of this section, the competence of a court shall be determined irrespective of any provision as to a right of appeal from the decision of such court. Under explanation 2, they're talking about the competency of court. We have to remember this much, right? Explanation 3. The matter above referred to must, in a former suit, have been alleged by one party and either denied or admitted expressly or impliedly by the other party. That is what they're saying, that the matter which was referred or was in dispute in the suit was alleged by one party and it must have been denied or admitted by the other party, right? Now come to explanation 4. This explanation is very important, and this is asked many times in so many exams. It says any matter which might and ought to have been made a ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. That is what they are saying is, so herein they're talking about the concept of constructive res judicata, and they're saying that if a matter, so in any suit, what happens? It is the duties of party that whatever matter directly and substantially in issue, and it is in their knowledge, or it is something which they could have known by due diligence, it is their duty to state all those things in the all those things and facts in the plaint, right? That is, it is their duties to make a comprehensive suit so that a final and a conclusive decision can be reached, right? So yeah, under explanation 4, what they're saying is to file a plaint which is comprehensive and it has all the facts and all the important issues are covered in the plaint, so that a conclusive judgment can be given, right? So because what will happen, suppose if there is a case and what happens if there is a case and you forgot or you did not quote some of the important issues which were there in the, which should have been quoted or to have been stated by you in the plaint, but you did not. And later, and suppose and the judgment was not given in your favor, and now what you do is again you file a case by saying that by putting up some new grounds and saying now I'm filing this case on the basis of this ground. This you cannot do, and you'll be barred by the principle of constructive res judicata, because the court will say this issue you should have raised back then in that former suit. Now you will not be allowed to file a fresh suit on that issue, right? So on this ground, we have one very landmark case, which is the state of UP versus Nawab Hussain. In this case, what happened? There was a writ petition filed, and it was filed because the plaintiff was removed from his services, and he contended that I was removed by DIG without being provided any notice. His petition was dismissed. Now again he filed a petition, and now what he contended that since the appointing authority of me was IG, then how could DIG remove me from my service? So I should be reinstated in my service. But again, court gave and quoted the concept of constructive res judicata, and it said that this issue was ought to have been raised by you in the former suit. Since you did not raise it in the earlier suit, you will not be allowed now to raise this issue and to file a suit on the basis of this issue, right? That is, the court was of the view that that the plaintiff should be vigilant about their rights. You cannot sleep on their rights and then expect the court to do justice, right? Be vigilant. Form a very comprehensive plaint. Okay, now let's read explanation number 5. Any relief claimed in the plaint which is not expressly granted by the decree shall, for the purposes of this section, be deemed to have been refused. Very simple. A claim which was asked in the plaint, but court did not grant that relief or was silent on that relief, it will be deemed to have been refused by the court, right? Explanation 6. Where persons litigate bona fide in respect of public right or of a private right claimed in common for themselves and others, all persons interested in such right shall, for the purposes of this section, be deemed to claim under the person so relating. This explanation they might ask in multiple choice question by saying which explanation relates to PIL. So you'll say explanation 6 talks about PIL, as it says persons litigate bona fide in respect of public right or of a private right claimed in common for themselves and others. Okay, now let's read explanation 8. The provisions of this section shall apply to a proceeding for the execution decree and reference in this section to any suit issue of former suit shall be construed as references respectively to proceedings for the execution of the decree, question arising in such proceeding, and a formal proceeding for the execution of that decree. This explanation was added in the year 1976, and under this explanation, what they're saying is that all these principles of res judicata applies to the execution proceedings also. Now let's read explanation 8. An issue heard and finally decided by a court of limited jurisdiction, competent to decide such issue, shall operate as res judicata in as subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit, or the suit in which such issue has been subsequently raised. So under explanation 8, they're talking about competent jurisdiction, and this limited, they're talking about limited jurisdiction, right? This limited jurisdiction can be with respect to subject matter or pecuniary, and res judicata even applies to these limited jurisdiction also, right? Now let's read some important case laws with respect to section 11. They might ask, what is the oldest case on section 11? It is Duchess of Kingstone. And Dariao versus UP, in this case, it was held that res judicata applies on writs, except on the writ of habeas corpus, right? And few more things they might ask, like res judicata does not apply on co-plaintiffs, res judicata does not apply upon co-defendant, but it applies to pro forma defendants, right? Now let's read section number 10, which says, which talks about res sub judice. See, this word is not clearly written in the Baer Act, right? In the Baer Act, they have written stay of suit. So, okay. Section 10. No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between the parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any court in India having jurisdiction to grant the relief claim, or in any court beyond the limits of India established or continued by the central government and having like jurisdiction, or before the Supreme Court. So under this section, what they're saying is that no court shall proceed with the trial of any suit, right? They are saying, if suppose if there is a suit which is already going on, which is pending in a court, and the matter which is directly and substantially in issue in that suit, and now you file a new case on the same ground, on the same issue, between the same parties and under the same title, and the previous matter is still pending, it is not decided yet, right? Then your suit will be stayed. That is, you cannot proceed with the trial of any suit with respect to that matter. So what is the difference between section 10 and section 11? In section 10, what they're saying is the suit should have been finally heard and decided, right? But here, what they're saying is the matter should be pending. If the matter is pending and all the conditions are fulfilled, then it will be a matter of res sub judice and not a matter of res judicata. Okay. So what is the test for res sub judice? If the final suit is decided, it's not, if the former suit is decided earlier, will it apply as res judicata on the subsequent suit? So that is to say, if the court in which the proceedings are already going on or are pending, suppose if that suit is finally heard and decided, will it apply as a res judicata on the present suit which is filed now on the same ground, on the same issue, same title and everything? If it applies as res judicata, then yeah, it will be suitable to call it as a case of res sub judice if the issue in the former suit is pending, right? Now, there's an explanation to this section which says the pendency of a suit in a foreign court does not preclude the courts in India from trying a suit founded on the same cause of action, right? So what under this explanation, what they're saying is res sub judice does not apply on foreign court. That is, suppose if there is a suit which is pending, or if there is a dispute or proceeding which is going on in a foreign court and it is pending there, it will not stop the courts in India from trying that matter. It can go on in India, right? For in foreign courts, it does not apply. Res sub judice does not apply on foreign courts, right? So now we will be going to what's section 12, which says where a plaintiff is precluded by rules from instituting a further suit in respect of any particular cause of action, he shall not be entitled to institute a suit in respect of such cause of action in any court to which this code applies. That is, if a plaintiff is not allowed by rules from instituting a suit on a particular cause of action, then he cannot file a civil suit with respect to the same cause of action in any other court, right? That is, on one cause of action you cannot file suit in multiple cases in multiple courts, right? So this is what they are saying. That is, if a suit is barred by the rules in respect of by the rules of this code, then you will not be allowed to file a fresh suit on the same cause of action. Now let's read section 13, which says which talks about foreign judgment. A foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except, what is they saying? Foreign judgment will be a conclusive proof as to any matter which is there by directly adjudicated. But it will not be conclusive judgment if it has not been pronounced by a court of competent jurisdiction and it was not given on the merits of the case, or where it appears on the face of the proceeding to be found on any incorrect view of international law or a refusal to recognize the law of India in cases in which such law is applicable, where the proceedings in which the judgment was obtained are opposed to natural justice, and where it has been obtained by fraud, and where it sustains a claim founded on a breach of any law in force in India. So basically, they are giving two grounds. If the judgment is based on if the judgment is hit by any of these grounds, then it will not be a conclusive judgment when given by a foreign court, right? And this list is actually exhaustive. You cannot consider or assume any other further ground. This is exhaustive list. Okay, and now let's move further. Section 14. The court shall presume upon the production of any document purporting to be certified copy of a foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless the contrary appears on the record, but such presumption may be displaced by proving want of jurisdiction. Here, under section 14, they are talking about there is a presumption that they're talking about, and that they're saying is that production of any document purporting to be a certified copy of a judgment. Suppose any judgment was given by a foreign court, and you now produce that in any court in India, it will be presumed to be a certified copy of that judgment, but it will always be a rebuttable presumption of law. You can always disprove that, right? And by proving you can always disprove or rebut that by giving your contrary or your evidences for disproving it, right? So under this section 14, they're talking about irrebuttable presumption as to the production of any document which is purported to be a certified copy of a foreign judgment. Now, the one question which arises, what about the what about the execution of foreign judgments? The execution of foreign judgments is done under section 44A of the CRPC, and section 44A of the CRPC talks about the execution of foreign judgments with the reciprocating territories. And if it is not a reciprocating territory, then what we have to do is we have to file for its enforcement. Then we have to file a suit for its enforcement, right? Section 44A talks about the execution of this foreign judgment with a reciprocating territory. If it is not a reciprocating territory, then file a civil suit for its execution within 3 years from the date of judgment, right? And there is one case law which is Satya versus Teja Singh, and it says foreign judgment is recognized in India on the consideration of justice, equity, and good conscience, right? So that's it. This is all for today's class. I hope you really liked and enjoyed this class today. Thank you so much.